This wasn't just a routine docket call. When jail behavior became an issue, the judge issued a serious warning, 6 months per violation, and she made it clear she could stack them.
Just my usual comments.
Good morning, you're Dalton Batiste. Answer out loud. And this is clause number 24, DCCR 0917, 0918, 25 DCCR 1436, 1437, and then 24 DCCR 0407. Mr. Batiste was charged in the first two cases with murder, second two with manslaughter, and the last with possession of marijuana. And what is the announcement?
We're still ready for trial.
The state's ready for trial as well, Judge. We would prefer to proceed on the felony possession of a marijuana case first. I understand the court some good pushback from the court on it, given the fact that it's just a Zoom.
I'm not doing it. There's no way I'm going to try to state jail felony. Tell us the other cases. So what are we actually? This is just an announcement. Did we get off the trial docket?
Yes, Judge.
Remind me, please.
Yes, we tried this case. We had a hung jury.
Yes.
The state elected to re-indict as manslaughter using the same theory essentially as before, but the challenge is, of course, I think you said it on review because that's essentially a totally different harm than the fentanyl murder statute that we were.
Right. And I'm fine. Obviously, I would, if the state's going, I guess I'm a little confused. Two murder charges are still pending. Typically, when it's perfect. Okay. So actually, we're just looking at the two manslaughters and the possession of marijuana. So I would, let's get it set then for a trial on the two manslaughter cases, and then see where we get from there.
Judge, the state's also filed a motion.
Yeah, so let's talk about that. So, Mr. Batiste, Mr. Coleman has filed a motion asking that I order you to act in a certain way out at our jail and to follow the rules and all of those things, which you should be doing anyway. I feel like we've probably already had this conversation, but what I can do, and here's what I don't necessarily want. I don't disagree with Mr. Coleman a single bit. You can ask Mr. Gertz. You can ask anybody that's been in front of me about how I feel about what is going on at our jail and how disrespectful inmates are being to the staff out there. And I'm doing whatever I can to try to get through to you all because it can make things much worse. Much worse. Number one, if you go to trial on the manslaughter and you're found guilty, the jury's going to hear about all of it. We're going to march these correctional officers in here, and they're going to say what you've been saying to them that I'm not going to say today because a lot of people are watching. But you know what you're saying. You know how you're acting. I can promise you Mr. Gertz is embarrassed for you because you don't help him help you by acting this way. Does that make sense? You're not one of these kids out there. How old are you? 26. So typically I'm dealing with 17, 18, 19-year-olds that are out there acting crazy. You're too old for that. What I don't want to do, Mr. Coleman, though, is cause the jail more grief by holding him in contempt and making him stay there even longer. Here's what we're going to do. We're getting the case set for trial on the manslaughters. We're going to get those tried. I'm not sure what I will do if you violate this exactly. I can't tell you right now, but I am ordering you to refrain from calling names. And if you need me to tell you everything, I can. If I need to be specific, I'll be specific. Because what I don't want you to come in here and say, well, I didn't say bitch, I said whatever. You know what I'm saying? Behave. Don't call names. Don't tell them they don't have rank. Don't tell them I get what I want. B. That's not how you talk to somebody who's just going to do their job. They're just trying to go do their job and go home. And they got to deal with you and all the other people out there that are acting like idiots. So I'm going to order you to not do that. What that means is if you violate that order and do it, and I get more incident reports, Mr. Coleman will ask me to hold you in contempt. And what I can do for every single incident, for every name you call, for every time you get written up, for every time you don't follow the rules, I can hold you in contempt and I can order 6 months. And then I can stack 6 months for every name. Every time you say it, I can stack it. Do you understand? So you are now court ordered. Follow the rules. Which I shouldn't have to do, but I am. Okay? So I will set these cases for trial at the very next trial setting that we can get them on, and we'll go forward at the time. All right.
Thank you, Judge.
You can go back to the bailiff.
So another one, she was ordered to go to ISF, got into a fight, got kicked out. She just got on probation
Now meet a mile.
a couple months ago.
There's nothing we can do. So she can be true or not true, and we'll listen to the hearings, and it'll be up to me if there's no agreement. If she can't make it through, I can't just let her out. There's no, I mean, I don't have a choice. Can't get better.
Yeah. I didn't know if there was any other alternatives, but
Ma'am, are you Almeida Miles? And Ms. Miles, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? You can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
yes, sure.
Ms. Miles, in cause number 24, DCCR 2330, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation September 16th of 2025 for the offense of tampering, fabricating with physical evidence, a third-degree felony, and that was a 10-year deferred probation. Is that correct? The motion alleges you violated your probation. Count 1 alleges that you failed to.
Some of them are power down.
Okay,
Well, it counts.
we'll start with this one, then we'll see. So count 1 alleges that you failed to avoid injurious or vicious habits, in that you physically assaulted another offender in the B3 pod on or about the 6th day of November 2025 at the Henley unit, which is the ISF unit. Is that true or not true? Count 2 alleges that you failed to complete the education program, the GED program, because you stated that you were tired and did not feel like going to school so early in the morning every day. Is that true or not true? True or not true? Sounds ridiculous when you hear it read back to you, doesn't it? Count 3 alleges that you failed to enter and successfully complete the ISF program, and that you were removed based on behavioral issues. Is that true or not true? Count 4. Well, it's different. Count 4 alleges that you failed to comply with all of the directions of the ISF program and that you engaged in sexual misconduct while participating at the Henley Unit ISF. Is that true or not true? And then count 5 alleges that you failed to comply with all of the directives of the ISF program and that you were walking around in the quote living area of the dorm during count time against the rules. That's also at the Henley unit. Is that true or not true? That one's not true.
The court wasn't debating guilt at this moment. It was about conduct, respect, and consequences inside custody. Judges have broad contempt powers, and here, that authority was front and center.
And voluntarily. And you plead true to those counts because they're actually true. And then I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. What I would like to do, I'm going to reset it. I don't know that I need, because she really hasn't been out full update, but I would like as much information as we can get from ISF. So if they have reports that you guys can get your hands on so that I can read more about what went on there, that will help me, I think, with sentencing. Anything that you think is important for me to know, get Ms. Holmes to be out there to visit with you, tell her all of that. She'll present it to me on your behalf when we come back for sentencing, and then I'll decide what to do. All right, you can go back with the bailiff. Oh, wait, Miss, come back for a second. So, Miss Miles, I do want to make sure you understand. Obviously, it's important how you behave when you're in custody. And so anything that happens between now and when you come back for sentencing in our jail is only going to make things worse. So my suggestion is you better get out there, you better lay low, and you better follow all of the rules, because anything that I might be thinking about doing is going to go up in years if you're out there misbehaving. Go back. Good morning, sir. Are you Eric Awara? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Wara, in cause number 24, DCCR 2344, the state is elected to proceed on count one only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon from October 19th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Well,
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holt?
yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence Mr. Juarez is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with that agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in this case. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to us. All right, good luck to you, sir. You can go back with the later. Good morning, sir. Are you John Dre Willis? This is cause number 25 DCCR 1048. Mr. Willis was previously in court, entered a plea of guilty to burglary of a habitation. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor. I have judging in light of the fact of the Louisiana murder
Yeah.
case. I know the PSI came in a tablet late due to no fault of her own. Miss Carvin had a death in the family, so I would like the opportunity. It seems silly to put him on probation and he has a hold on that. So, just for clarification, he's not the suspect. There actually has been someone else indicted for that case. He's a witness that they're holding. So he's not the defendant in the murder. Okay, it just reflected that. Yeah, they do have a hold. No, he's not charged with the murder.
Okay.
But he is a key witness in the murder.
Okay. They put their witnesses in custody.
That's what I was told.
I'm sorry?
The other detectives.
They
They came to visit him.
They came here. Okay.
So that's what I've been told. Would you like me to confirm any?
I just
Yeah,
yeah, you
can-
other than through him, did you That's just what your defendant, which, and I'm not saying I don't believe you.
Yeah, that's what has been relayed to me.
Okay,
So-
let's do this. Sorry. Let's, I don't know if you can
I can reach out to Kevin.
reach out now and see if you can make sure that 'cause this morning we can go ahead and go forward this morning. If for some
Okay.
reason you can't, we'll just reset it 1 week or something.
Okay.
So just have a seat, wherever the bailiff wants you to, and we'll see if we can get that done.
Okay.
Good morning. Are you Derek Butler? This is cause number 25 DCCR 1653. Mr. Butler is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Yes, there is some media after this case that I need to do with my client.
Okay.
I just need a little time to do that. Talk to Mr. Smith about the issues I've been having for that video.
Okay.
And so we just need a little time to get that thing.
Okay. So you're having trouble pulling it up.
Well, it's not that, it's just a factual issue.
Oh, gotcha.
resulting
Okay.
from it.
So do you need a normal reset or just maybe a little shorter?
Actually, a little short. We don't have to be normal research.
Let's do about 3 weeks.
Yeah, that'd be perfect.
And so, Mr. Butler, Mr. Lewis will be out there soon, I'm sure, to go over all of that discovery, and then you guys will be able to make a decision and have an announcement for the next court date. All right, thank you.
Thank you, Jim. Yeah, yes.
Thank you, sir. Isaiah Cheatham, good morning. Are you Isaiah Cheatham?
Yes, Your Honor.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does too.
Mr. Cheatham, in cause number 22-40220, I have a motion.
In a single docket session, we saw trial settings, probation revocations, and a 10-year prison sentence imposed. Courtroom authority isn't just symbolic, it carries real weight. And every word, every action, can affect what happens next.